Hello and welcome to Family Law in BC. My name is Stephanie Talbot and I am a family lawyer in British Columbia. Today we're going to talk about child support in British Columbia. And I just want to begin with a standard disclaimer that this video is intended to be legal information. It is not legal advice. And if you are experiencing a family law issue of your own, it's important for you to seek individualized legal advice from somebody who practices in your jurisdiction. So we'll be talking about child support in British Columbia, but the child support guidelines that we determine child support under are actually a federal piece of legislation, the Federal Child Support Guidelines. So it's going to be similar from province to province. Maybe Quebec might be different. That's a whole other thing, but generally speaking, across Canada, we're going to be dealing with the same piece of legislation. So one of the most important things that you have to figure out before you can determine child support is what the parenting arrangements are, because that will help us determine how we calculate child support. So if you have a situation where one parent has 60% or more, I should say more than 60% of the parenting time with a child, then the child support calculation is going to be quite straightforward, because basically you just look at the income of the parent who does not have the majority of the parenting time and the number of children. And there's a calculator that we use. It's basically based on a table, and it'll just spit out the amount of child support just based on the number of children and the income of the person who's paying the child support. So that's pretty straightforward. There is provision in the child support guidelines for like an undue hardship type circumstance, but it's very difficult to argue for undue hardship to pay less than the guideline amount of child support. So you'd have to have pretty extreme circumstances to be successful with that, and I'm not going to really get into the details of that here. So then the other scenario where you might be calculating child support would be in a situation where you have some form of shared parenting, and that's kind of defined as being like between a 60-40 split of the parenting time and a 50-50 split of the parenting time. So roughly equal parenting time between the two parents. And so in that circumstance, what comes into play is Section 9 of the Federal Child Support Guidelines, which tells us that we need to, look at the guideline amounts of child support for each parent, meaning how much parent one would pay if parent two had all the parenting time or the majority of the parenting time, more than 60%, and how much parent two would pay if parent one had more than 60% of the parenting time, and then compare those two amounts. So like in a situation where the parents have similar incomes, if we compare those two amounts, they're going to, be similar amounts, and one way to deal with that would just be to say that there's no child support payable by either parent. But Section 9 of the Federal Child Support Guidelines kind of asks us to go a step further, and it wants us to consider number one, the increased cost of having a shared parenting arrangement. And that just means looking at, obviously if both parents have to have a full home setup for the children, there's going to be additional costs to both of the families, right? Or I should say duplicated costs, having two beds, having, I guess toothbrushes isn't as big of a deal, but some of those things, you might have two bikes, that sort of thing, right? So just having a shared parenting arrangement is a greater cost usually to the entire family unit for both households. And then the other thing too is that they want us to take a look at the needs, means, conditions, and other circumstances of both of the parents and also obviously the children, right? And so a question that comes up a lot when we're looking at child support is people saying like, oh, well, will my new partner's income be taken into account when we're calculating child support? And there's not 100% straightforward response to that. If you have a situation where one parent has more than 60% of the parenting time, then we're not working under Section 9. We're not having to take into account these, needs, means, other circumstances, and that sort of thing, right? So if you have, one parent with the majority of the parenting time, then either parent's new partner's income wouldn't factor into the amount of child support payable. But when you have a shared parenting arrangement, it is possible that the court could take into account the income of a new partner for either of the parents. If a new partner also has children, then they can take into account that, like the total number of people in the household, and whether or not that new partner is receiving child support for their own children, and how this new family unit has structured their finances and sort of things, under needs, means, conditions, other circumstances. You could also theoretically be taking into account the relative capital positions of the two parents. So if one parent has way more money in, whether it's in real estate or stocks or anything like that, that could theoretically be taken into account when calculating the child support in a shared parenting situation. So kind of the guideline, I shouldn't say guideline, I should say kind of the starting point would be to look at the amount payable by both parents. If the other parent had the majority of the parenting time. And then one kind of starting off place would be to do an offset, which would mean the parent with the higher income, you'd take their guideline amount of child support, and from that you would subtract the guideline amount of child support from the parent with the lower income, and then potentially the amount that would be payable in those circumstances would be whatever is left over when you subtract the lower amount from the higher amount. Then the higher income earning parent would be paying that offset amount to the lower income earning parent. And that's kind of the simplified way of doing things. But if you do look at even just Section 9 of the guidelines, and also some of the case law that's come up from the courts about this, it's pretty clear that when you have a shared parenting arrangement, there really should be a more in-depth consideration of the circumstances of both households. Now, certainly if two parents agree that they're just going to do the offset, that's totally fine. But, when there's disagreement about that, that's kind of where these other things come into play. And so that is one way of doing things. But like the other thing too, though, is that sometimes you have split parenting where you have one child living majority of the time with one parent, another child living the majority of time with the other parent. And in those circumstances, the offset does just apply. And sometimes you can get into situations where, more than two children, one child's living full-time with mom, the other two kids are going back and forth. So it can get a little bit complicated, but we definitely have calculators available that can help us sort out those more interesting circumstances that sometimes arise. And so I think that's all that I have for you today. I think I'm going to leave it there. So again, if you are experiencing family law issues, I would encourage you to seek independent legal advice from a lawyer who practices in your jurisdiction. And if you're interested in working with me, you can certainly visit my website, www.flowfamilylaw.com. I'll put that address in the notes, and I'll also just link to the government child support calculator website, which is kind of the basic calculator for child support. All right, thanks for tuning in. Until next time.